All right, court next calls the people of the state of Michigan versus Philip Andrew Lefers.
And yes.
This is all right. This is case number 26819FY. We are here for a probable cause conference. We're also here. Mr. Champion has filed documents on behalf of Mr. Lefers. One of those is an affidavit of non-acceptance of court.
Right from the start, this hearing takes a dramatic turn. The defendant isn't just fighting the charges. He's questioning whether the court even has authority over him. That instantly raises attention inside the courtroom.
Appointed counsel, assertion of constitutional rights, and demand for self-representation. The other is an affidavit of notice and acknowledgement and acceptance of oath of public official. The other is a respondent's motion to set aside a default judgment. Appearances, counsel.
Lisa Doe for the people.
Robert Hertel for the Defender's Office. Your Honor, Mr. Champion was in Misaki this morning. I'm sure the court also took note that what we, from the Defender's Office filed, we included a qualifier of it not necessarily being endorsed by the Public Defender's Office. I wanted to make sure to stress that.
Correct, I understand that. So, Mr. Lefers, I know, I think you've been in front of me twice, and I think you were in front of Judge Ransom last time. I know your position regarding the authority of the court. To keep matters moving, though, I have to set a time limit as to how long I'm going to allow you to address the court. Hold that thought. I know you always have a concern, and rightly so, as to whether or not we're on the record. My concern is from where you're standing, I'm not sure the microphones are able to pick you up well enough to get an accurate record, and the court reporter is telling me that. So what I'm willing to do for purposes of this case is
Watch how carefully the judge handles this moment. He's trying to keep the proceedings moving, while also making sure the defendant can't later claim he was denied a fair chance to speak. It's courtroom strategy in real time.
going to put on notice that allowing you to pass behind the bar and enter into the well, I'm not agreeing to take jurisdiction over you. I'm allowing you to come forward so that you can make the appropriate record that you wish. Because my concern is, even if you project your voice, sometimes the microphones are just these little triangular things on the table. So my concern is they're not going to pick you up. So I would prefer that you come in and sit next to counsel's table. I don't exercise jurisdiction over you by doing that if you choose to come forward.
All right, so thank you.
All right. If you can come up and have a seat next to Mr. Hertel. So, Mr. Lefers, we're already past noon.
Sir.
So what I'm willing to do is, do you think you can state what you want to state within will 5 minutes be enough time?
I'll do my best.
All right, so I show we're at about, well, I'll give you, my desktop says 12:05. It looks like the wall clocks say 12:06, and it looks like they're synced up with each other, so go ahead.
No disrespect intended. Are we on the public record, sir?
We are.
And as redundant as it might be, just please continue to be honorable. Your Honor, I am Phil Lefers, lawful representative of the estate in question.
Here comes a constitutional challenge. Arguments about jurisdiction and constitutional authority are common in these types of cases, but courts rarely accept them as a valid defense. Still, they always create intense courtroom exchanges.
I want it on the record. Y'all don't have jurisdiction. Your Honor, I voluntarily appear in this court today on special appearance. I move the court to take judicial notice of the Michigan Constitution as ratified without subsequent amendments in the U.S. Constitution and your oath to them, Your Honor. What say you?
Well, as I said before, I acknowledge I took an oath to uphold the constitutions.
Thank you, sir. Moving forward, Article 3, Section 2, Clause 2 clearly states that when a state is a party to the case involving a citizen of that state, the Supreme Court has original jurisdiction, which makes these proceedings improper, violate the Constitution. It's the wrong venue. The request that I've supplied, which I have to amend, because now there are extra things added. And Mr. Champion also and RJ at the defender's office refused to allow us evidence. So I'm still being denied due process.
Now, this part is legally significant. The defendant is invoking his Sixth Amendment right to represent himself. What courts call proceeding pro se. Judges are legally required to make sure that decision is made knowingly and voluntarily.
Your Honor, for the record, I am making a clear and unequivocal demand to represent myself in this matter. I am invoking my Sixth Amendment right, as recognized by the United States Supreme Court of Ferretta versus California, 422 U.S. 806, 1975. And we have read up on the Wiggins. What? McClaskill, that's right. The McClaskill and Wiggins and implied change in law. I do not accept standby counsel, which affirms my right to proceed without counsel when the waiver is made knowingly and intelligently. I respectfully decline any court-appointed attorney. You all are friends. Y'all know each other. You most recently took this seat, sir. I made friends with a lot of my coworkers in the past. I'm not going to get a fair trial here. Due process is being denied on that as well. I understand the nature of the charges against me, the penalty, and the risk involved in self-representation. I am making this decision knowingly, intelligently, and voluntarily. I ask the court to conduct any required inquiry to establish that my waiver of counsel is valid and to allow me to proceed pro se. Your Honor, I am making a clear and unequivocal demand to proceed pro se under Ferretta. I am not asking for different counsel. I am waiving counsel entirely. They are impeding upon my due process. Jawkins didn't give me anything that I asked for. In fact, he got upset at me, cussed at me, told me to mind my own business, look over this. Jurisdiction is broken. Due process is broken. I'm not being treated fairly. That is my stance. If you want to indict me on a grand jury trial, please do so. Otherwise, this needs to be dismissed with prejudice or full exoneration.
Did you hear that? The conversation suddenly jumps from a local courtroom all the way to the United States Supreme Court. The judge stays composed, but you can tell he's trying to keep the discussion grounded in actual court procedure.
Pull the trigger. Let me go up there. I'll talk to them. It's been a pleasure meeting you.
Well, it's been a pleasure meeting you too. When you say go up and talk to them, who do you mean?
Supreme Court.
Okay, all right.
On a federal indictment, which as a national, we're in different jurisdictions, sir.
So, I understand you want to represent yourself. I have a couple questions in that regard. So, first of all, by representing yourself, do you believe that you can conform to the rules of the court, the published court rules?
With that, finding out other things. Most recently about my hometown. The past 2 judges have been removed by the tenure council. So canon 1 through 5, indeed, it also expresses that you're the guardian. Prosecutor is the guardian. Lawyers are guardians of our liberties and the constitutional right. So when someone pro se makes a mistake, and even unpro se, the prosecutor is supposed to be there to uphold justice, not pervert it. And that's what this is about. So canon 1 through 5, if I make a mistake, please correct me. If I file something wrong, the clerk has let me and my wife know, okay, well, this isn't how we do this. We can accept an amendment, you write it in, blah, blah, blah. Okay, so I will do the best I can. I am very different since dying, coma, botch.
This is where the atmosphere changes. Once a defendant mentions memory loss and traumatic brain injuries, the judge immediately becomes more cautious. That's because the court has to determine whether someone is truly capable of representing themselves.
Surgeries. I'm a permanent head trauma case. My short-term memory is gone. So unless I build a consecutive day after day, that same time, every time, I'm not going to remember. And Einstein said it is worthless to waste brain power on things that you can write down.
So, so as the independent party here, and just so you know, I don't know how, I'm guessing you've probably done some checking into me, but I don't know. Before I was the judge, I was the prosecutor. Before I was the prosecutor, I was a public defender. So I've played roles in all 3 parts here. So
I watched your videos while you were a judge. I watched the one of the 2 gentlemen that were arrested, and you released them. You dismissed their case. They were arrested over off of 13th or something over by a body shop, running meth. But the officers, same 2 officers that are involved in my case, tandem, like they do most of the times, which is why they were so close together on my case. They had to realize that they had to be closer together after you threw that case out. They broke the Constitution. I watched what you did, and I watched 2 other videos, which they fully got what they deserved. They broke the law, unequivocally. But those 2 gentlemen, yes, had the Constitution not been broken, you would have been just fine with proceeding forward with not dismissing their case. But on the grounds that the first thing that the officers did, they broke the law, and then they broke the Constitution, which is exactly what's going on here. My wife and I have been involved in several auto accidents where the Cadillac Police Department refused to fill out a police report. There's not $1,000 worth of damages. The lady dragged her vehicle all the way down the whole side of our truck, from the bumper to the front quarter panel. The captain of the Cadillac Police Department and 5 others were there, and they wouldn't write a ticket. So these 2 officers and other officers state, well, we don't have to do anything.